We're joined by a host of legal minds here to help us address and describe the questions that the court will be facing. Deborah Pearlstein, constitutional law professor at Princeton University. Let's begin with you, if I can. One of the key questions before the court today will be, is the presidency an office as described in the 14th Amendment? Is that an easy question? I mean, as a layman, strikes me that that's how we tend to describe it, but is it an open question?
Well, it's an open question to the extent that the court has never had occasion to decide it. But your instinct is right. It would seem strange, and there is a constitutional argument, a very strong one, that it would seem strange that we would pass this amendment to the Constitution that excludes every other public official from office if they've engaged in insurrection, and not exclude the most senior public official of all, the President of the United States. Nonetheless, there is a technical legal argument that's been made by and on behalf of the former president that says, well, office, right? The president appoints officers. The president has other responsibilities, but the president himself is not named in Section 3 of the 14th Amendment. The office of the president is not named, and it doesn't make sense to construe it as an office in the same sense that we construe senators, congressmen, and the other sorts of federal officers that are listed explicitly in Section 3 of the 14th Amendment.
Okay, Seth Berenzweig, also with us, constitutional attorney. The language says, anyone who shall have engaged in an insurrection or rebellion against the same, the Constitution, the government, or given aid or comfort to enemies thereof, the court has to decide, Seth, was this an insurrection? Or do they have to decide? Could they sidestep that question?
They can, but they don't want to, and they probably won't. They're looking for a procedural off-ramp. I'm going to be listening very carefully to what the conservative justices are saying this morning. The conservative justices are going to be tugged in very opposite directions. On the one hand, historically, the conservative justices of the Supreme Court are what we call originalists or textualists, and they want to apply the language, and the language that you just stated is quite frankly very clear. On the other hand, they are going to probably try to find a way to twist themselves in a procedural pretzel to find an off-ramp to try to avoid that issue. So it's going to be really fascinating. The language at issue itself is really rather clear. So for example, one of the issues is whether or not it requires an independent act of Congress. But that language that you indicated a few moments ago also said that upon an insurrection or aid or comfort, that is a disability, an automatic disability, and the only reference to congressional action is to remove such disability upon 2/3 of the vote of Congress. So we'll be fascinating to see what the conservative justices ask this morning.
If you're just joining us now, we're awaiting the beginning of oral arguments in the case of the state of Colorado, which its own court has ruled that Trump should not appear on the ballot there because of a violation of the 14th Amendment. The Supreme Court will hear oral arguments today, and we will be listening in for those live as they happen. Deborah Pearlstein, there's another question here, and that is of recusal, because you have the quite unusual circumstances where one of the justices considering this, Justice Clarence Thomas, his wife, Ginny Thomas, was involved. She was in touch with some of those involved in January 6th on the day and days prior and afterwards. Should he be hearing these arguments today?
My own view is that Clarence Thomas should be recused from this case for precisely this reason. And indeed, the Supreme Court just a few months ago issued a new set of ethics rules that it indicated it was going to be bound by, and set forth the terms by which they would evaluate for themselves whether a justice should recuse or not. That said, and the appearance of a conflict of interest here being strong and of concern, I've seen no indication so far that Justice Thomas has any plans to recuse in this case. A justice can make that decision at any time, in theory, but it seems unlikely to happen. And even the court's own non-binding ethics standards say the justices take into account whether an individual justice's recusal will have an impact on the case, right? There's only one Supreme Court. There are only 9 justices. If one justice is the deciding vote in a particularly weighty issue, right, that might weigh, according to the court, in their own consideration about when to recuse or not. But to be clear, there is currently no enforcement mechanism of any kind and no other authority to which one might turn on the question of whether a justice should or must recuse or not. It is really up to the individual justice and that justice alone.
Voluntary, self-policing, you might call it. Seth Berenzweig, another question for the judges, the justices today, is the issue of due process. Trump has not been found guilty of insurrection. And, of course, we should note the House did impeachment, but he was acquitted in his Senate trial, not receiving enough votes, although we should note the Senate majority leader at the time, or minority leader, Mitch McConnell, said that that was a question for the courts. How do justices approach that question? Can they decide, well, yes, perhaps a president could be held from a ballot if convicted of insurrection, but that has not happened here?
Well, that will certainly be one of the issues on the plate today because, as you've very correctly noted, there's going to be a very significant question raised as to whether he would be precluded from receiving due process in an instance where it would be perhaps self-executing. The counter argument to that is that each state has its own internal rules and process. And in this case in Colorado, there was an evidentiary hearing, there was process, there was an opportunity to be heard, and under Supreme Court precedent, procedural due process is defined as a meaningful opportunity to be heard. So you're right, this is definitely going to be an issue as to whether or not due process was afforded, and I think this might be one of the easier off-ramps for the justices because a lot of the procedural arguments in the case really border on the frivolous. Whether or not he is an officer, obviously he's within the office of the presidency. So this is something that will come up. I believe that it's not a very good argument because due process was arguably afforded. There was an evidentiary hearing in Colorado, but certainly that will be one of the issues that will come up during the hearing this morning.